Joining us in the studio this morning is Knox County State's Attorney Jermey Karlin. Good morning, Mr. Karlin.
Good morning.
Good to see you. How are you?
I'm doing all right. I'm. It's been a kind of a long weekend. I dropped off my kid at college, and there's the sadness that ensues on the drive back home. But she's already written me this morning, and she actually woke up for class, and everything's good.
Good.
Right.
Where's she going to school at?
She's going to Kalamazoo College in Kalamazoo, Michigan.
Sure, that was a bit of a drive.
About 4.5 hours, yeah.
Not bad, though.
Yeah, not bad. You also get a time change in the way back, so it feels like a gain an hour.
Okay, perfect. Well, good luck to her at college.
Thank you.
They started a little bit later. Usually it's Labor Day weekend.
I don't know. They start the same time that Knox does. So Knox starts today, and I have a stepson who just started today as well. But that was an easier drive to get him into school.
Absolutely,
just down the street.
Well, we're here today. We're about a week away from the very interesting policy that is going to take place. It was Illinois will become the first state to eliminate cash bail. That's Illinois Supreme Court on July 18th upheld the Pretrial Fairness Act ruling and said it did not violate the Illinois Constitution. Catch us up from there.
Well, okay. Well, kind of going back a little bit, the legislature had had passed the Pretrial Fairness Act or the Safety Act. And then we had they made some changes in November of last year that really undid all the preparation that we were making for the effective date of December 31st. And then as we were getting closer to that date, a lawsuit was filed, and the Supreme Court put a stay on the litigation. It's a litigation that myself and a number of other states' attorneys had joined to test the constitutionality of the statute. For me, it was not necessarily because I thought the statute was unconstitutional, but I wanted to have it addressed in one case as opposed to on a case-by-case situation with hundreds of defendants. And so I thought this was the most efficient way of doing it. So come this summer, after the briefing, the Supreme Court has decided that it is constitutional, and we now have an effective date of September 18th, a week from now. And all of us state's attorneys and law enforcement and court officials have been scrambling to make sure that we are ready to go come 12:01 on Monday.
And you have a training. Actually, you've been conducting numerous trainings, so we can talk about those and set the stage for the upcoming September 14th training that's open to communities, and that's through Zoom, so anybody can join.
Right. I mean, first of all, it is a substantial change in how we do things for law enforcement, for our jail personnel, for our courthouse, as well as my office as well. Fundamentally, it's not different in the respect that there are three groups of defendants that we see. There are defendants that we know should be held in jail pending trial. There are defendants we know who ought not to. And there's ones in the middle where it's a gray area. And we've always had that issue. And the Pretrial Fairness Act has kind of codified that issue for us. And we've now have a different set of rules. For me, frankly, I think there are a lot of good things about the Pretrial Fairness Act. For example, for all people, whether or not you commit murder, commit arson, commit serious crimes, we're always setting bail. And we try to set bail high enough so that we don't think that people will get out. And so you set bail on a drug dealer for $500,000, and then lo and behold, this guy has $50,000 cash to get out. And you're thinking, how did that happen? Under the Pretrial Fairness Act, we're not going to go through that process anymore. If you commit a serious crime, you're going to be held in custody until trial. As well as, people on the other end of cases where they're committing a low-level felony that is victimless. You set bail on a low amount, and, 2 weeks later, you're like, how did they not come up with $300 to get out? And so we're going to be able to avoid the problems on both sides of that equation. It's just it is, though, a formula, and that the law enforcement has to consider at the time of the arrest. But there's been so much misinformation about this, or fear, because it's a big change, and everyone's always concerned when there's a big change, that people who will be letting out when they ought not be. And that's why we're having the community training on Zoom on Thursday. And if you sign up in advance, it's pre-registration required. You'll go through the training that I've been doing for police officers. There's a number of flow charts that have been developed that allow police officers to have a decision tree from, if it's a low-level crime, a B or C misdemeanor, they'll be given a citation right there on the street and let go, as opposed to being brought to the jail and booked in. If it's a more serious offense, and perhaps not an offense that's detainable, or the person on the street doesn't give proper ID, or it's a low-level offense, but they keep on doing it, like a trespasser who keeps on going back to the same place, they'll be brought to the station and booked in. And at that point, there's a decision. Either they're there on a detainable offense and they'll be held for an initial appearance, or there are other circumstances that, in the discretion of the police officer, they should be held for an initial appearance. And at that point, that's when the prosecutors jump in. The prosecutor takes a look at the crime, determines whether or not we wish to actually do pretrial detention or not. And at that point, we can, if we choose not to detain them, we can release them, but with special conditions. Like stay away from an address, stay away from an individual. Sometimes, depending on the circumstances, refrain from using drugs, get mental health evaluation. Those things are a little complicated, but we can get through that. Or if we're going to detain them, then we have to file a petition to detain, and we have to establish that they are there on a detainable offense, and that they either pose a risk of harm to specific people or the community, or they pose a risk of willful flight.
Okay.
I know that's a lot, sorry about that.
But definitely understanding the breakdown of the Safety Act, if you will, and how that's going to look for law enforcement, the prosecutors, the judges. So for law enforcement, that formula, you've been doing training on that, correct? Right.
We've done about 4 trainings so far. I've done training in 5 trainings actually. 4. Okay. I've done 1 training for the courthouse staff, so that's like circuit clerks and public defenders, courthouse security, because that's going to change. I've done 1 training for the jail, because even that's going to change. Right now, if you get a warrant for, let's say you get arrested in Knox County, it's a warrant for Henderson County. Typically what would happen now is you just get shipped to Henderson County. Under the Safety Act, what will happen is you get seen by a Knox County judge initially, and then there's a 5-day timer on it. And if after 5 days Henderson County hasn't come to get them, then there could be another hearing in Knox County in which they could be released on special conditions, or any number of things. Or it could be set up that Henderson County can have a virtual hearing in Knox County on this warrant. Someone's going to be seen by a judge. So that's different for our jail. And then, of course, for law enforcement, I just talked about kind of the decision tree of, is it a low-level offense? If not, is it an offense that we should see them booked? And if it's more serious than that, are we going to hold them for pretrial detention? The flow charts that are involved with this, it kind of reminds me, those football players that have the plays on their forearms.
Quarterbacks, yeah.
Quarterbacks, I feel like we ought to be providing a list of those flow charts for forearms of all our law enforcement, so they can kind of go through on the street what it's going to look like.
Sure, because any way you look at it, the same problem still exists inherently for a law enforcement. And correct me if I'm wrong, you obviously see this daily, but it's the repeat offenders over and over and over again, that it's a low-level nuisance offense almost is what you want to call it, whether it be trespassing, drugs, you name it, needing a
Right.
mental health evaluation. It still doesn't eliminate that source of challenge.
Well, we've always had that challenge in that because there's a dearth, a very limited, not very limited, but there's insufficient mental health treatment resources or addiction resources in our areas. We're kind of using. It then falls to law enforcement to have a response, and it is to some degree trying to put a square peg in a round hole because, the criminal justice system assumes that you're a rational actor, right? And if we're dealing with an individual who has mental health concerns or committing crimes of addiction, it's a little more of a challenge. Under the Safety Act, because we are limited in our ability to hold on to people, we have to work through that. I mean, right now, if someone is committing low-level crimes but indicate that there's something from a mental health perspective going on, we kind of can hold on to people until we get them into a facility or into a treatment situation, and then we can protect the community and the individual that way. The Safety Act, to some degree, handcuffs us on that, or we all have to be on the same page. The public defender, the judge, the state's attorney, kind of winking at each other. Okay, this is what we're doing. We talk about problem-solving courts and having like drug courts or mental health courts. We are solving problems every day in our bail call and our custody call, luckily we are a small enough community where in Knox County there's only 50,000 of us, 30,000 in Galesburg. The problems that we see have names, faces, people that we know, and so we generally can kind of amongst even in the adversarial process between the public defender, defense attorney, myself, and the judge, we generally can figure out what we need to do with this individual to get them the help that they need. Most of the people that I deal with there's some people who are evil, of course, and people who commit terrible crimes, and those are people who we need to hold in jail and then exile out of the community. But the vast amount of people that we see are people who need our help. And so it's important throughout this process as a prosecutor to have compassion and empathy to get these people the help that they need, because they are really, literally, our brothers, our sisters, our family members, our friends. And that's what you want out of a prosecutor, both heavy-handedness on the people who need it, but also compassion for those who need help.
We're talking with Knox County State's Attorney Jermey Karlin. So, Jeremy, I want to ask this: you've given us some of the pros from a prosecutor standpoint that you see. What are the reasons why a lot of our police officers or law enforcement, I should say, and some of the state's attorneys not in favor of this pretrial Fairness Act?
Well,
and have those problems been resolved?
I think a lot of those problems were resolved in the trailer bill that came out in November. If you want to meet a group that is more resistant, I can't think of a group that is more resistant to change than prosecutors. Primarily because we're doing the best that we can to try to figure out solutions within the system that we have, and when the system changes, then we're all scrambling. It's kind of like what I say in my office. I hate interesting. When it's boring, when it's mundane, when I know what I'm doing, that's when I'm the happiest, ironically. It's when it starts to get interesting and the solutions are not as clear-cut. I don't like my job as much. But so that's why you see prosecutors and law enforcement concerned about this. I think as we start to get into the system, we can we can see that there are a number of decision points along the way that allow law enforcement to exercise the discretion to detain people, or at the very least, not detain them through the full process until trial, but at least hold on to them for a day or two, so we can determine what's the next best step for the individual who is in custody.
Okay. What else do you want people to know as we embark upon the implementation of the Act in 1 week?
Well, what I'd like to talk about is that we're dealing with a lot of lack of knowledge and training about the Safety Act and law enforcement professionals. I think that fear is multiplied, times 10 in the community. And, first of all, I appreciate being able to come on with you and talk about it to your listeners. We are also offering Safety Act training to our community here, whoever wants to join up. And it's on this Thursday at 5 o'clock. If you go to my Facebook post site, Knox County State's Attorney Jermey Karlin, you can get a link for just to sign up and just to pre-register, so we know who we're dealing with, and then you can go through the same training that I'm doing with law enforcement to show the flow charts, to show what we are focusing on, those situations where people will be initially held on to, but we won't be filing a petition to detain, and under those circumstances, we'll be imposing special conditions. And what are the challenges for that? And I think as people become aware of what we're doing, become aware that this is not a legal boondoggle, we will be able to work through it. Just like anything. But it's going to take some extra work. So, for example, come September 18th, for the following 5 weeks, I'm going to be the on-call attorney in Knox County. So we have on-call attorneys for law enforcement where they can call 24/7 to ask questions about, is this stop legal? How do I get a search? I need to get a search warrant. I need you to come on down. Whatever. And so, given I assume that we're going to have a lot of questions in the first couple of weeks, I intend to be the on-call attorney, not only so I can answer questions for law enforcement, but also so if I see that there are difficulties in the implementation in our system that we've set up, I can be on the spot making those changes. Additionally, we have a lot of stakeholders in this process. I mean, it's not just me telling law enforcement what to do, but it's also somewhat of it's a conversation with our judges about what they want to see happen, as well as the public defenders and defense attorneys, where they think there are problems with the system, and so we're trying to, anticipate these issues. I'll be meeting with Administrative Judge Andrew Doyle in Knox County, as well as our public defender David Hansen. We'll be meeting actually later today as we go through the forms that we have prepared, as we go through step by step to see if where there may be some difficulties.
Sure. And of course, we will reach out to Tom Siegel, our state's attorney here in Warren County, and have him on the air coming up later this month as well.
Oh, yeah. And, I think it's important to have all of us, it's important to talk about it now, right? Have us come back in a month or so, and maybe even longer than that, 2 months, so we can talk about how it went. And I am hoping, I guess, that we'll be surprised that this is a relatively smooth process. I think what we're going to find is that fewer people will be held in custody. Only a small few. It's not going to be not much of a change, because the people who should be held in custody are generally going to be held in custody, right? And the people who should be released are going to be released. So what it's all going to mean is that we're going to have the same amount of people, plus or minus 2 or 3, being held in custody, but it's going to be a lot more work for my office to make that happen.
Sure. And that's ultimately what it sounds like, is we have an entire act, if you will, but it sounds like the ability to get a speedy trial due to lack of resources has been a challenge statewide, nationwide. You hear about, at least the way it was written in articles, that so-and-so, for a low-level offense was sitting in custody for a month at a time. Mm-hmm. Why is a low-level offender not able to get a quicker trial, if you will.
Well,
And I think that's
it's not
one
so
that-
much of a speedy trial issue. The trials come along. It's more of a, why is a person who has a drug addiction sitting in our jail when that time would be better served for them getting treatment? You know, the period of time for people who have crimes or committing crimes of addiction or mental illness, you know, that period of time from arrest to ultimate resolution is one of the best opportunities that we have to get them on the path of recovery. You know, because you have the coercive ability of, that's maybe too strong a word, the strong ability for us to affect their behavior by encouraging them to do it, saying like, hey, if you're found guilty, the sentencing is going to go a lot easier if you've demonstrated that you're already working on these issues. So that period of time, we want to make sure that people are getting the help that they need. We don't want them sitting in our jail. We want them getting the help. We don't have, maybe, down the road we'll have better drug treatment in our jails. It's going to take some financial investment. And, I mean, that's actually does point out one of the flaws of the system that we're dealing with, is that it is important to have bail reform. That the whether or not you sit in jail or not should not depend on the size of your bank account. Absolutely. I think we all can get behind that. On the other hand, if we're going to release people who should be released, there needs to be then another network of resources that they can access to help them deal with the issues that brought them into custody in the first place. That's where the state has kind of fallen down. Now, that takes a real financial commitment, as well as solving some other problems that are difficult, which are finding sufficient number of mental health professionals, addiction professionals that are willing to come to Illinois, who are willing to come to our rural areas to provide this treatment. It's going to require hospitals to make that financial investment to provide facilities to do that. The state really needs to come in and incentivize that behavior so that while people are out on custody, people who ought to be out on custody are able to deal with the issues that got them arrested in the first place.
That was going to be my next point, was the need for drug addiction resources and mental health resources. I used to play ball before COVID shut us down with some of the guys who work at Henry Hill, right? Mm-hmm. And I asked him one day, I said, so the gentlemen who are in custody, what usually gets them in there in the first place? And they said drugs and alcohol. That most of the crimes are committed while on some sort of a substance. So that was too bad to hear.
Yeah, and it's also not only drugs and alcohol, but it's also the people who have mental health who are self-medicating, and so it's a whole group of problems that get them on the wrong side of the law. That we really, in order to make our community safer, we need to be addressing those issues ultimately. I mean, because ultimately, at the end of the day, we have punitive measures that we can take towards individuals to get people to follow the law, right? That's one tool that we have. But, just like with our children, we don't send our children to bed without supper because we are just trying to punish them. We send them to bed without supper because we're trying to correct behavior, right? We don't just, punish to punish. And so if we are trying to help individuals who are misbehaving correct their behavior, we need to provide the resources to do it. Actually, a better example would be this. If your kid is coming home and getting bad grades at school, grounding them for 2 weeks is not going to solve that problem. Getting them a tutor, maybe sitting down with them as they do their homework so you're available as a parent, that's going to help them get better grades, right? For individuals who are having mental health issues or drug addictions, grounding them by putting them in jail for a period of time isn't necessarily the best result. Getting them help they need with counselors or whatever is really the thing that's going to get people on the path to recovery and the path to lawfulness.
So, what would you do with the crime part of the accountability if they were if they committed the act while having a mental illness issue, that still
you
has
see,
to be
that's
dealt
the
with.
real challenge because, laws always, it's very rarely a black and white situation, right? People who, I call it, there in my world, there's meth and there's meth plus. Meth is, they get pulled over on a traffic stop and they have meth in the car, right? They have addiction. Meth plus is they are breaking into people's houses to steal stuff, to pawn, to get money for meth. Now that is now no longer a victimless crime, right? Yeah, that's a situation where there's victims whose security has been threatened, maybe even been physically harmed. That's a situation where, while we take into account their mental illness or their drug addiction, we have to maybe segregate them from the community for a period of time while they're getting that treatment. And that really does point to the segregation being the punishment, of course. The segregation being during that period of time we know that we'll be safe. But we need that kind of focuses on the third prong, which is we send people away who are bad. We get people who are out in the community getting treatment. But people who pose risks to the community while untreated, we need to start providing those same resources within our jail. And that's a constant. Of course, it's a challenge because we're really talking about county dollars going to do that at this point. Sheriffs are, as a group, not necessarily very equipped to do that. I've joked with our last sheriff and the sheriff we have now in Knox County that our sheriff was the largest provider of mental health services in Knox County. That's not very surprising. If we can do a better job of having NA and AA in our jail, having medical professionals who can diagnose and treat these issues while in jail, for people who are in jail, we are using that time not only as a punishment, punitively, we're using that time constructively so that when they get out, they perhaps provide they're less of a risk of harm to the community. You can see that we are trying to solve problems in the absence of a community-wide system of mental health treatment and drug treatment. We have to do the best that they can within the system that we have to do this.
Okay. Well, thank you so much for coming in today.
Thank you. I'm sorry I'm so long-winded, but I'm pretty passionate about this stuff.
A lot of information to go over. A reminder, September 14th at 5 p.m., there is a Safety Act training that's open to the community, hosted on Zoom. Pre-registration is required. You can find that link on our website under top stories for Community Safety Act training with Knox County State's Attorney Jermey Karlin. Thank you.
Thank you so much.
Have a good week.
Yeah, you too.
Let's join RFD, already in progress.